Good afternoon, and welcome to the SafetyTek Multiple Insuring Agreement with Data Breach Protection webinar, hosted by Stuckey and Company. My name is Tyler Bechtel, the Business Development Representative here at Stuckey, and we appreciate everyone joining us today and for your time this Wednesday afternoon. It does look like we have a few people still logging on. However, let's go ahead and we'll jump through a few things before we get started. First, if you'd like to ask a question, over on the right-hand side on the GoToWebinar control panel, please ask any questions, and we will certainly get back to you by email answering your questions after the webinar. All right, so about us. Stuckey & Company is an MGA, and we provide our insurance agents and brokers with innovative insurance programs, along with excellent service that they need to ensure long-term growth and success. As of today, Stuckey has 9 specialty insurance programs for our agents, and this year Stuckey has completed 26 years in the business and started our 27th year as of 2018, while serving over 200,000 customers and providing excellent unmatched service from our 151 promise. Here at Stuckey, we create niche specialty insurance programs for our agents, and we do everything such as underwriting, rating, quoting, binding, policy issuance, change requests and endorsements, renewal issuance, billing and invoicing, reporting, systems integration, claims, marketing, and training, such as this webinar today. Here are 8 of our specialty insurance programs that we offer to our agents. We have our SafetyTek, our technology E&O insurance program, which will be discussed here further in a few minutes. We have Aspire A&E for architects and engineers. Arbor Guard, Stuckey's first program, started 27 years ago, which handles marinas and boat dealers. We have our miscellaneous professional liability, which consists of over 320 classes in MPL. Element, our green energy industry. And then we have our personal lines, which consist of home, auto, boat, high value home, and more. And then we also have our commercial lines, which includes BOP, work comp, commercial auto, bonds. And lastly, we also have our E&S or surplus lines markets if anything falls outside of our underwriting guidelines. All right, so now I'd like to turn it over to Maggie Hammett, our lead technology underwriter here at Stuckey, and she would like to go into further detail of the multiple insuring agreement with data breach protection. Maggie?
Thanks, Tyler. I'd like to give a little background of Stuckey & Company, as I see we have a few new agents logged in and joining us today. And I want to thank everyone for your interest and participating in our multiple insuring agreement with data breach webinar. First, Stuckey & Company has over 20 years of underwriting technology professionals. We are experienced in all aspects of the professional risks. We realize some firms may not always just offer technology. Sometimes it spans over into a management consulting, and we kind of get a good feel of what companies are offering. We have a great understanding of contracts that they might require, particularly for the technology professionals. And then in-house authority, we can go up to $25 million in revenue, and we can also do $5 million and $5 million limits as long as it's per a contract. So let's go ahead. In this training webinar, I want to share with you our policy form definitions. Multiple insuring agreement with data breach consists of 3 parts: electronic media activity liability, network operations security, and then the data breach fund. And this insuring agreement is for first-party coverage. So this is actually for the insured's computer system. And then let's go in, we'll go into some details as far as what's considered electronic media, the advertising services, some intellectual property infringements included, and what we define as electronic content. And then we'll go into the network operations, where we discuss some privacy regulations, the unauthorized use and access of a computer system, the insured's computer system. And then we have a new extension that we can add in, and it's the data breach fund. And that would be for notification expense, credit monitoring, forensics investigation. Again, keep in mind that the things I'm talking about today are actually for the insured. So this would be the insured's computer system, if they had some type of a breach on their computer system. So let's discuss the electronic media activities liability. We're going to break down some of the definitions, and this would be electronic publishing, dissemination, releasing, gathering, and transmission, the production, the webcasting, and any electronic content on the internet on behalf of the insured or by the insured for others. And some of the things that we talk about coverage for advertising is promotional material disseminated on the internet website on behalf of the named insured, and some advertising services, promotional material publicly disseminated by the insured on the insured's website on behalf of others. This is the intellectual property part of the electronic media that I was kind of referring to. So the definitions include any form of defamation or tort related to the disparagement or harm to the reputation or character of a person or organization, and this would be the libel, slander, product, trade libel, infliction, emotional distress, mental anguish, outrage or outrageous conduct, invasion, infringement, interference with the right to privacy or publicity, including false light, public disclosure of private facts, intrusion, commercial appropriation of name, persona, or likeness. We have plagiarism, piracy, unauthorized use of an advertising idea. Advertising materials would include title, literacy, artistic format, style of performance, and then we also have the copyright, domain name, trademark, trade name, trade dress, your slogan, service mark, and service name, and then negligence with respect to the insured's creation or dissemination of electronic content. So quite a bit of broad definitions included in electronic media. So let's kind of line out what we consider electronic content. This would be any data, text, sound, images, similar matter, advertising services, and then electronically on the insured's internet website. Let's talk about what the network operations security insuring agreement would pick up. This is where we talk about the privacy regulations, the control and use of personal identifiable financial, medical, or other sensitive information, and this would include your HIPAA, any healthcare insurance information, your Graham-Leach-Bliley Act, the California Security Breach Notification Act, and any other similar state, federal, or foreign identity. You know there's many states that regulate how you store and protect data, personal private information, so this is where the privacy regulation in the multiple insuring agreement would pick up. And then, of course, they defined also what would be considered personal information, and sometimes it's the individual's name in combination with one or more of the following, and that would be a social security number, medical or healthcare data, or other protected health information, driver's license number, or a state ID number, or any other non-public personal information as defined in the privacy regulations. The network operations security specifically is for the insured's computer system. This is whether it's leased, owned, or operated by the insured, or operated solely for the benefit of the insured by a third-party service provider. It would have to be under written contract with the insured. Unauthorized access, gaining access to a computer system by an unauthorized person, or unauthorized use, which is use of a computer system by, again, an unauthorized person or persons. So let's talk about the data breach fund. This has recently been added to our multiple insuring agreement. And this data breach fund, again, keep in mind it applies to the insured's data and the insured's computer system. So consider first-party coverage. We do have a sublimit on the first-party coverage of $250,000, and this would be for any third-party forensics to determine scope of security or failure, the notification expenses that we all hear about, including voluntary notification, credit monitoring, retaining services of public relation firm, crisis management firm to protect or restore the insured's reputation, and then law firm services to determine the indemnification rights of the independent contractor. Here's something I have quite a few agents contact me and asking. I try to be very clear. You always have a first-party exposure versus a third-party exposure. So let's kind of break that down a little bit. The first-party data is the insured's data. So I consider this, it's the insured's data that they're not hired to protect. So they may have employees' information on their computer system where they do like a direct deposit into a bank account, of course, federal taxes, that would include their employee's name, social security number, of course, maybe healthcare information, or maybe they store their client's billing information if they have a contract where they do monthly upgrades and support where they just automatically bill a particular account with their client's number and bank information. Those are first-party exposures, the data that's on the insured's computer system where they are not hired to secure that data. That's what the multiple insuring agreement is for, and what the data breach extension is for, is to cover our insured, give them a little bit of coverage. Then, of course, the third-party data, which is considered Tech E&O, is third-party coverage. This would be for the client's data. This is where the insured is hired to secure data. Their client's information, typically they'll get a contract that they've been hired to secure networks where the client holds their data, their private data. So it would be network servers, web hosting. Anything the insured is hired to secure is actually picked up in a Tech E&O form, because that is truly a third-party E&O coverage. Keep in mind the SafetyTek form offered by Stuckey & Company is out there to provide coverage for both the first-party and third-party exposures, the insured and the insured's clients and their data. So let's talk about some importance of coverage. Of course, in some of these training webinars, if you've attended, Tyler's been doing some training webinars on CoverCore, and also becoming a resource for your clients. We want clients to come to agents as a resource and look to you for guidance, and we want to prepare you with the knowledge and kind of give you an idea of what insureds need, especially in the tech industry. As you can see, probably one of the largest scare for most insureds is data, and it's some type of data breach. So you want to make sure that you are familiar with the insured's needs. Of course, always ask if there's a contractual obligation. Typically, the contracts we see will require professional liability, cyber liability, general liability, any additional insureds. We can add additional insureds to the technology E&O form. It just has to be a contract requirement. Again, as I mentioned before too, we can go up to $5 million limits based on contract requirements. And then, most agents will know the state regulatory guidelines in the states that you're licensed in, but you also want to probably be aware if you are offering coverage in other states, kind of get up to date on what some of their state regulations may be. And then, of course, the importance of coverage is it protects the insured from a devastating financial loss should something occur. That was a pretty short and sweet webinar, giving a lot of information. I definitely wanted to hit home with what third-party and first-party cyber coverage is, and kind of show you the definitions of our policy form and how we pick it up. I provided contact information. for myself. If you have any underwriting questions or coverage questions, you can definitely contact me. If you're interested in having access to our new CoverCore communication platform, feel free to contact Tyler. We've actually been having great success with setting up our agents on CoverCore, getting your profile set up, and then once you get involved in the CoverCore communications, we've been providing leads. Some of you, I believe, I recognize some names. We've had some one-on-web tutorials. So feel free to contact Tyler with getting set up on that. You can also access any of your insurance that you currently write for us. Through us, you can get a copy of your documents via the communication platform, policy, endorsements, invoicing, kind of things like that. We want to make sure you have access to all that information to review. Lastly, I want to mention that we will be sending out a follow-up email to everyone that's attended, including a link to the recording of this webinar, and I'll also provide you some information as far as the policy form application, some highlights, just some knowledgeable things to help you become a resource as we've been working really hard to train our agents on. So that wraps it up for me and Tyler. I don't see that we have any questions. I think I've covered a lot. I took a small section out of our multiple insuring agreement and just wanted to give you the highlights of what's covered under that. No questions. You guys are great. Thank you. I've got some thank yous up here, and I appreciate that. I hope we're doing our job and making you guys a resource. And, of course, always, if you have questions, feel free to give me a call. I love having one-on-one conversations with you guys to help with your clients. Thank you, and have a great day.